We will get started with our work session, the State Board of Education work session. It will now come to order. Denise, will you please call the roll?
Glenn Flint.
Here.
Lily Larson. Present. Patrick McPherson.
Present.
Maureen Nichols. Molly O'Halloran. Patricia Tim. Yes. Rachel Wise.
Here.
John Witzel.
Here.
Commissioner Bloomstead.
Present.
6 present, 2 absent.
Thank you, Denise. Information regarding the Open Meetings Act is posted on the east wall of this room on the south side of the door. Live web streaming will be available through the State Board of Education website, www.education.ne.gov/stateboard. Board members, please remember to engage your phones before speaking and turn them off when you're finished. And please turn off personal cell phones. Thank you. We'll move to board reports, dates, and discussion items. First is any meeting participation in joint meetings over the past month. John, would you like to report out over the past month where you've been and what you've been doing?
Thank you. Thank you very much. I was honored to be a guest at the curriculum department at the Pavilion Livista Public Schools. We discussed various issues, including standards and building curriculum and various stakeholder involvement issues. But it was a very nice exchange of, if you will, ideas and information. Secondly, briefed a book publishers club about how they can, if you will, submit books for sale in their local schools. Met with the Omaha Chamber of Commerce in regards to some of the trending they're seeing in regards to trades, skilled trades, what we have an overage of and what we have a shortfall of in the state. Met with the Metro Mentoring Partnership where we discussed future plans for growth opportunities. And also working with the SAC Museum for possible opportunities to partner with museum and future STEM initiatives. And lastly, the Metro Community College and the Latino Center of the Midlands is having a GED graduation formal on July the 3rd at 1 o'clock at the South Campus. Thank you.
Thanks, John. Anyone else want to report out? Pat?
Well, because you've had me in so many meetings, I don't have all the information I need, but I went to Johnson, Nebraska, earlier in May, and had the honor of helping present to their history teacher, Lori, the history teacher of the year. And the award is a gentleman's name that I don't remember because I gave all my information to one of the media people. So, thank you. That's who it was. But anyway, delightful woman, and she had like 20 of her family there. I mean, they were very supportive of her, and she will then also go on to the national. Her application will go on to this national organization for the national as well, and I think she received $1,000 and some other nice things. So it was very nice.
Great, thanks. Glenn? Okay.
Pass.
Okay. Lily? Just real quick, a couple of things. I was at ESU2 and met with all of their staff and their end of their year work sessions. Visited Blair Public Schools and had a great visit with some of the things that they're doing in Blair. And then had an opportunity. The United Way out of Dodge County serves both Dodge and Washington County, and they, in partnership with Rotary and Kiwanis, distribute books to all students grades K through 4. And they do right before the end of the school year, last day or second last day, and I had a chance to be in some of the elementary schools in Dodge and Washington County, and that was just a great experience to see kids get books with little notes that said, you get to keep the books, you don't have to return those books. So it's a push they have for literacy in Dodge and Washington County. You've got in your materials the list of meeting requests that are coming forward. We can talk about that tomorrow. If you've got any upcoming meetings that you're aware of that you didn't get your name on the list yet, please do so. And tomorrow when we take action, we'll take a look at that list. Are there any questions on the upcoming meetings? If not, we'll move on to the Commissioner's Report and Agenda Overview, and I'll turn it over to Commissioner Bloomstead.
Yeah, and first of all, I'll just go ahead and regular consent agenda process. This time, if you have one of those pink slips, please give it to Scott Summers. Scott, as you know, is is taking the responsibilities for general legal counsel. And even though Margaret's still here this month, Scott is here, so certainly turn that over to Scott. I'm actually mentioning Scott now. We're going to go ahead and jump down to the background information on Title IX. Scott's going to come forward and do a little bit of that presentation in advance of the Attorney General. And thank you, Attorney General Peterson, for being here today. And Scott will give a little bit of that update. I will come back and talk more, not to leave anything out for you later. So.
I heard you.
Thank you.
I gotta get this, make sure this is up.
While Scott's kind of getting ready, first of all, we had a meeting with the Attorney General and staff over there, and appreciated that, and had talked about trying to give a little bit of background information on Title IX generally, so that kind of sets the stage for the rest of our conversation. So.
Do you think I need to do to put it up on the screen?
No, I'll put it up.
Whenever I'm ready. Well, good afternoon. As the commissioner stated, he asked me to provide some real basic information about a very newsworthy item, Title IX. I'm kind of like the local opening band for the major act. So if you need to go get snacks or go to the restroom now. Speaking of restrooms.
Yeah, that was.
I'm not going to get into that. That's a little bit beyond the scope of this. I'm going to hit just some of the real basic ideas for Title IX and kind of set the table for the discussion to come. So I just wanted to give you that. The purpose of my part this afternoon is to tell you things that you may very well already know. But let's have a look. Title IX is a federal statute, and if you go back to your middle school civics, you know that would essentially mean it is enacted by the legislative branch, i.e. Congress. This goes back to 1972, and the meat of the statute is very overwhelmingly simple. The entirety of the statute that we're really talking about is this, and I won't read it to you, but it is part of the United States Code. It has this prohibition against sexual discrimination for folks that are in receipt of federal funding. And the rest of Title IX after that piece is essentially devoted to exceptions to this, general rule, and some pieces about enforcement. What is Title IX not? Well, Title IX does not require an intent to violate it. It only reaches things that have the effect of treating men and women differently based on sex. It does not require preferences or quotas, but it can permit affirmative action as a remedial measure from previous or past discrimination if so found. And it applies institution-wide in our educational institutions and programs, meaning it's not a program within the institution-specific thing. And some examples are it would apply to classrooms, extracurricular, and reaches athletic competition. And that's also in the news lately. If you read anything about there's been a complaint filed at Baylor University in regard to Title IX. And also, and you probably know this as well, while it requires non-discrimination and essentially equal treatment of the two sexes in athletics, we do not violate Title IX every Saturday in the fall down here at Memorial Stadium. It's more about equal opportunity to participate, and there can be gender-specific segregation, for lack of a better word, in contact sports and for some other reasons. Consequences of a school district violating or being accused of violating Title IX. Well, the U.S. Department of Education Office of Civil Rights, OCR as it's commonly referred to, can investigate and require remedial measures. The ultimate sanction, of course, being what is also in the news now, loss of federal funding. They can investigate based on complaints. They can investigate based on their own prompting. There is a private right of action by individuals that could include, by private right of action I mean essentially lawsuit, from private individuals that could include monetary recovery against an institution that harmed them by virtue of violating Title IX. But both of these actions are suits for violations of Title IX, and they're confined to complaints and remedies as to the institution, such as a school district or university, as the defendant, not named individuals in terms of officers or administrators. That's been pretty well hashed out. It can apply to private schools that accept federal funds. Examples include E-rate, school lunch. Though the private schools controlled by religious organizations have exemptions in the law to the extent that complying with Title IX would in some respect or respects conflict with an applicable religious tenet. And usually those are sought and given in a procedural written request and response format. Regulations. Well, you saw the law, and it's very bare bones. The regulations, on the other hand, which began a few years after the effective date of the law, is in about 3. They have 61 sections, along with the incorporation of sections from other regulations. So here's the so-called meat on the bone being driven by the executive branch. 34 CFR Part 106, if you're keeping track at home. Get my right clicker on. The regulations, in addition to fleshing out some terms and things that appear in the law, require assurances by federal fund recipients when they apply for and receive federal funds. They provide for things such as what the United States Secretary of Education may do if noncompliance by a recipient is found. They talk about how entities have to designate a Title IX rep, have to have internal complaint procedures, provide for hearing in the event of complaints, admission practice requirements, and employment practices, because it also reaches employment within such institutions and its own employment and employees. Complaints by any person about noncompliance. My mic not close enough, sorry. Any person that perceives there's been a violation of Title IX at an applicable institution, they can file a complaint with the OCR, and the OCR has investigative powers. If noncompliance is found, they try first to seek informal resolution. They call it. I won't go into great detail about that. But again, the big hammer is if that doesn't work, they have the ability to suspend or terminate federal funds, but not before a due process hearing is made available to the recipient. And those are few and far in between, I believe. And in implementing and policing Title IX, the United States Department of Education, Office of Civil Rights, have issued various guidance documents over the years addressing how it intends to interpret and enforce these Title IX laws and regulations. And of course, the one that's made the news here recently has to do with the transgender bathroom issue. Title IX goes mainly to the school districts in terms of their responsibilities at the school district level. It is the districts that are responsible for their own compliance, their own complaint and procedures, their notices and things like that. The Department of Education, us, we are not the super police of Title IX as to all districts. We ourselves are subject to Title IX, and we have to comply with Title IX in our own day-to-day operations here in terms of our employment and something like issuing teaching certificates, for example. But at the district level, it is a district issue. But I bring the last set of slides here to show you that there is some, very least tangential relationship to SEAs, state education agencies like ourselves. Recipients of financial assistance from the U.S. Department of Education in regards to offering or administering programs of vocational or educational training, which is more commonly known as Perkins Funds, which I'm sure you've heard of. These federal funds are applied for and awarded to the state education agencies in the form of a block grant, and these funds are distributed per a legal regulatory formula to our school districts that have vocational education programs. My understanding is at this time of all our districts, all but one have vocational or so-called CTE, career technical education programs that relate to these funds. So what does the department do in terms of this subrecipient block grant. We have, as an SEA that distributes these funds, oversight responsibilities is the term used in the regulation as to the Perkins subrecipients, which are school districts and some post-secondary institutions, not the University of Nebraska. The SEA is to conduct, and the department does conduct, periodic compliance reviews of these entities to assure there's not unlawful discrimination in the career tech programs or any part of the facilities used by these students. That would include compliance with Title IX, among some of the other equal opportunity type laws that you think of when you think of that. The folks here that deal with the program and the teaching and learning could provide you many more particulars, but these compliance visits are not, I think they're very, very thorough and they're very time consuming, but they only grab a small portion at a time. We conduct, and this is per the U.S. Department of Education procedures, we conduct visits of 2.5% of those sub-recipients each year. So the numbers of schools aren't large, but the work that goes into the visiting those numbers is. The result of these compliance visit is a standard report, much of the content of which the questions asked, the report given are based on things issued by the U.S. Department of Education that the state education agency is to do and ask and look at during these visits. However, last part of the presentation, warm-up band's almost done. The United States Department of Education has stated that in performing this oversight compliance as a state education agency, we have no power to, nor are we required to terminate or defer or suspend the federal funds. That's not our role. We don't have those teeth. It is, again, technical compliance, it is assistance, and it is the filling and completion of these reports about the visits, and those reports are, I believe, every 2 years, but on a certain schedule provided by us and all other SEAs to the Department of Education Office of Civil Rights. So I hope that kind of sets a real general table now in terms of Title IX, so we can dig in a little deeper. And if you have any quick questions outside of getting deep into transgender bathroom things, I'll do my best to respond.
Any questions? Yeah, Lily?
In the very, very beginning, it refers
Your mic on.
to men and women.
Mm-hmm.
So is that an age group that it applies to, or is it just female, male?
I think female, male. I don't even, I'm sure you're right, I didn't catch that, but it's going to apply to the treatment of students that are very much minors.
It's
Yeah.
early on in your presentation, I just noticed
Right.
that.
I think that was used in the general. I don't think it is intended, and I didn't intend to apply it to age of majority, age of minority kind of things.
Any other questions? I have a quick question. Relative to vocational rehabilitation services,
Mm-hmm.
is there a relationship around our responsibility with vocational rehabilitation services and Title IX, and do you know what that might be?
A real general answer is yes, I believe Title IX would apply. They receive federal funds.
Funds, right.
They are part of an organization that, in the Department of Education, distributes money, Perkins and such, so they do have some Title IX compliance. Now, specific programmatic dealings, if a vocational rehabilitation client was aggrieved because they claimed they were treated differently as a female, for example, I've never dug into, if we received an OCR complaint, how we would respond to that. If there's, I don't know how that would flesh out, but.
Lily?
I have another question,
Mhm.
sir. It applied to approved and accredited schools, or just accredited? Title
Well,
IX.
Title IX would apply, it depends on the receipt of federal funds from
And
federal
whether they
government.
receive the funds or
Right, and that was
not.
kind of part of it. It would apply to all federal, Title IX would apply to all school districts because they're gonna inevitably get money directly or indirectly federally. private schools might be subject depending on what federal are going there. Because it's programs and institutions, yeah.
So along those lines, for non-public schools, private schools that may be receiving services such as special education services, or maybe some, if there's some Title I kinds of services provided, if they're the recipient as a non-public school of those services, then
Yeah,
it would
there's some
apply
nuance.
to a service,
Yeah.
not just funding, direct funding, but also to the provision of a service with that.
There's some nuances there that I'm not terribly familiar with, but it
Okay.
can come to bear on private
Okay.
schools.
Thank you.
Anything else?
Any other questions of Scott? Thank you. Commissioner Hall?
So I certainly would welcome the Attorney General up. I know he's got a little bit of a time schedule here, but again, I really appreciate your ability to be here today and always help us bring clarity to things. I know that's the part of the big role you have. So thank you for being here.
Thank you, Matt. And Scott, my recollection in my younger days was that the lead band was always far better than the actual, or the warm-up band was better than the main band. So now you've got me befuddled. I want to just talk to you quickly about in the roles Attorney General in the Nebraska Department of Justice, some interaction that we've found that is important with school districts. In our role, we have a portion of our office, a significant portion dedicated to criminal prosecution across the state, felony prosecution. But in that, we will occasionally address juvenile situations. But one thing that's very apparent to us in regards to our criminal prosecution is how many of the individuals we're dealing with develop some of these patterns at the junior high school level. And so we've been trying to be proactive in going out to the schools. I've been, for the last year, a little over a year, trying to take the opportunity to speak to schools about particularly the Constitution, but also we'll talk about, one of the things we'll frequently talk about is cell phone security and also issues with regards to marijuana. So one of the things I do want to bring to the board's attention is that the Department of Justice is interacting with Nebraska schools, primarily at the high school level, and we're finding that it's well received. The three primary areas that we will be interacting in with the school districts is, number one, we have a program called Digital Citizenship, where we send our communications and community education person, Ryan Sothen, goes and speaks to a lot of high schools and junior highs. In fact, he just recently with Lincoln Public Schools has set up a schedule with, I think, 12 presentations to families and children about the use of the internet. One of the most discouraging things you will see in our office is the type of activity that goes on the internet, and particularly now what we're seeing with cell phones. I went to one particular county, and what I try to do when I travel around is I try to go to different counties, meet with law enforcement, and ask them what are the type of patterns of crimes that you're seeing, and also get a sense of if those are common across the state. And one fairly close county, they shared with me that in the last 2 months they'd had over 6 incidents where high school students had taken photos on their phones or got into discussions with strangers on their phones, and then eventually, after revealing compromising photos, then the threat came, send $2,000 or I'll expose this to everyone on your contact list. We also know that there have been a couple of incidents where that's happened on more of a personal, where there is actually a known relationship between the people sharing these photos, and that they threatened, in effect, it's bullying or blackmail, that they would disclose that. And in 2 cases we know of where children have actually committed suicide out of the shame and concern that they had if their names or if the information were revealed to family friends. One of the things that's so frustrating about it is some of the scammers who are doing this are from Eastern Bloc European countries. And we have absolutely no way of reaching those to try to enforce or protect. So we understand that the best way to address that is to try to teach the students beforehand how important it is to be smart about the phone. So that's one of the things we're doing as far as interaction. The other one that I didn't really foresee us getting involved in, but I think it's important, and that is the marijuana industry. And this came up basically from talking to school districts or being in school districts across Nebraska, including the Panhandle. I asked administrators what are they saying with regards to the Colorado marijuana, and what they say, the two things that students, and it's interesting, what these students are, they're not stupid. We've educated our kids well in Nebraska, because what they say two things is, one, if Colorado legalized it, it can't be dangerous. And number two, our penalties in Nebraska with regards to less than an ounce of marijuana are simply an infraction. They're pretty weak penalties. And so the word they get is, frankly, you could get in more trouble with alcohol than you could with marijuana. And it used to be limited to western Nebraska, but now there's no question it's spread across the state. Just a couple weeks ago, to give you an idea of how profitable this industry is, just a couple weeks ago, I was speaking with law enforcement in a fairly small community, and they said that they'd recently arrested an 18-year-old who just graduated. He was paid $73,000 to go to Colorado and pick up loads of marijuana and deliver it into 3 communities. It's called muling. So he muled marijuana to 3 communities. I don't have the exact quantities, and I know the communities it was delivered to, but I don't know the poundage. But the fact of the matter was, this young man was paid $73,000 in cash. He was given a location to pick that up in Denver. He never met with a person. This was all over the internet. In that internet communication, he was told that if he talked to any law enforcement, they knew where he lived. So the people from Denver took a photograph of his home in a community of less than 1,000 and said, "We know where you live." So it's a very profitable industry, and one of the things that's very clear, frankly, we have a very good relationship with the Colorado Attorney General's office. And they've been very helpful in kind of telling us what they're seeing and some of their concerns. One of the biggest concerns I get from all of this is that the target market by the industry in Colorado are our young people. Much like the tobacco industry and the Joe Camel issue where they targeted young people, that's the exact same thing they're doing here. You don't put edible products in the type of things like pixie sticks if you're going after the 60-year-old retired railroader. And it's so apparent that they're going after these young people. Now, here's the biggest concern, I think, as adults, and what I'm trying to convey to school districts, is the strength of this drug is far stronger than anything you saw in the 70s and 80s. When I was in Colorado a little over a month ago with the Colorado Attorney General, we actually toured a facility. And it had both the recreational use, the medicinal use, and then they had a grow facility. Within that grow facility, I think he must have thought I was an investor, because when I was looking at one of the mature plants, I said, "What's the THC level on this plant?" The plant happened to be named Death Star. And he said 28.8%. We're tickled to death. Well, the THC level of the marijuana you saw in the 70s and 80s was probably in the 5 to 6%. And to give you an idea of how important this product is with regards to potency, prior to 2009, a pound of marijuana would sell in Omaha. It would come from Mexico, and it would sell for about $1,000 a pound. Once the medicinal marijuana was approved in Colorado, the word got back to Omaha that this stuff was stronger and better, and it started becoming a premium product. That new supply now became medicinal marijuana out of Colorado, and the price went up to $3,500 to $4,200 a pound. What happened as a result of that is the gangs became more involved with it. And when the gangs became more involved, it became much more violent. So that's what they see now currently in Omaha with the gang task force, is a much more competitive market for the stronger product. The other thing is what's frequently occurring now, particularly with edibles that account for over 40% of the market. Edibles are being sent somewhat freely through UPS, FedEx, and the Postal Service, because they're fairly confident that there's not a scent problem with the edibles as it's basically cooked into the product, and so that they can send that across state lines. And so the access is primarily now internet purchases and using that type of service. So the drug has become very available to our young people. One of the things I think is most consistent in the research that I've done is that in the developing mind, and there's different ranges, but certainly junior high and high school kids are developing minds, that the effect of the marijuana product and its potency causes a significant threat or concern for young people and their mental health, and such diagnostic conditions as paranoid schizophrenia, particularly when they get in that range of 17, 18, 19 years old when it's primarily diagnosed. Some kids are going to be predisposed, and if they have regular use, you're going to see them lower their threshold ability to withstand developing these mental conditions. So anyway, I never really anticipated in the role of Attorney General that I would be so involved in the marijuana issue, but I think it is important. I think the biggest thing that surprises me is the notion among us adults that it's not a big deal. And what I'm trying to get across to both students and adults is this product is a big deal. And the potency is significant. And if we're not on guard and making ourselves aware, we are really looking at a significant problem. And one other thing, I encourage you to do this tonight if you want. Go on the internet, type in video dabbing marijuana, or you could look up BHO. Basically, BHO stands for butane hash oil. And what is happening is the practice, particularly among young people, is that they will take a leaf product that already is stronger now. They will inject in it, they'll put it in a tube and they will inject butane fuel into it, which extracts out the hash oil. And then they make from that, it's a concentrate. And it's a product that you'll hear phrases wax, butter with 2 Ds, shatter. These are products where now they've condensed the strength of the product to 80% THC intensity. What happens is it's a much more intense high, it's a much more long-standing high, and it's a much more impairing type of high. And if you go and look up those videos, you can see about dabbing and the effects it will have. And what the biggest concern in the health community is, it's becoming the popular way to use marijuana products. And so with an 80% THC level, I think we're going to be looking at any kid who starts regularly practicing dabbing is going to be looking at some really potential long-term problems. So that's one of the other issues that we think the Department of Justice is important. Third one is in the area of human trafficking. If you, and I'm not, it's not self-promotion, it's just technical limitations, but if you go to our Twitter account, we have a story on there that I think is eye-opening for a lot of people. And it's a story that we took from the ABC News. And it's a story of a 14-year-old girl. And you look at this 14-year-old girl and you could see her in any school district in Nebraska. And it talks about how she got frustrated with her parents. She finally decided, I'm going to have an act of rebellion, and how she got pulled into human trafficking. And it talks about how her parents spent a year and a half trying to pull her out. But if you go to our Twitter account, you'll see this picture of this young girl in her soccer uniform. And it's a very fascinating story because I think oftentimes we in Nebraska think that human trafficking is not present, or we think it's only in really large cities, and it's not. As we are in our second year of this process, one of the things we're doing is trying to get out and speak to a lot of people in law enforcement on how to identify human trafficking victims. We're spending a lot of time trying to talk to community service providers, which would be medical providers. Most girls, some boys, but most girls who are trafficked, young girls trafficked through human trafficking, at one time or another have to use medical services. But the other thing is they're in our school system. Some of them are trafficked down I-80, but some are actually in our communities and being trafficked. A good human trafficker, I hate to use the word good, but if they have 4 girls working for them, they can make over $250,000 a year trafficking that young ladies, those 4 young girls. And so one of the things we're also trying to do is talk to our schools and how they might be able to identify and to be aware. And we're still, 2016 and 2017 is going to be a lot of awareness service provider efforts on our part, and Stephen O'Mara, who is our human trafficking coordinator. And so that will be important to talk to school administrators, teachers, to have a better understanding how to be aware of human trafficking and what type of signs to look for, because the students do quietly exist in our school system. And some of them, the real tragedy in human trafficking is so many of these young girls are so manipulated they don't fully understand that they're in a slavery situation. So the final thing I would talk about is just Title IX. And I think Scott covered it, so I will call it good. Now, it's a very difficult issue. I don't know if some of you, if you go on our webpage, I did have a letter that I sent to the Department of Justice and the Department of Education. What I would tell you is there's two concerns from my perspective. I'll start with the legal concern first. When the regulations were passed by the federal authorities under Title IX, one of the things they did is they passed a regulation that made it clear that this was to be only, the language was that Title IX does not prohibit any educational institution from maintaining separate toilet facilities, locker rooms, or living facilities for different sexes. So that was not only the federal regulation on that issue, but Nebraska also had a statute under the Nebraska Equal Education Act, and that's under Section 79-2124, which had the same provision that said, in conjunction with the federal Title IX law, the Nebraska state law made this distinction that you could have separate toilet, locker room, and living facilities. One of the patterns of actions that has caused a lot of litigation across the country is at the federal level, if you are going to change a regulation, the Federal Administrative Procedures Act requires that if you're going to change a regulation, you need to give notice that the agency intends to change the regulation, and then you need to give opportunity for comment. And what we've seen in a couple of cases, the federal agencies have chosen not to do that. They've just said that we as an administrative agency we can issue, for example, the Nebraska dispute with Colorado on marijuana was that change in federal policy and that decision not to enforce the Federal Controlled Substance Act was based upon a memo by the Department of Justice. That was not something that was fully debated on the legislative floor or given opportunity for comment. That was simply a memo issued by the Department of Justice. In the same hand, this particular issue is in a guidance letter. And so the frustration, or where we believe the unlawfulness has occurred, is that requires both notice and an opportunity for comment. So that's from a legal standpoint. There's also a question of separation of powers. There's a lot of legal theories that I can go into, but the most predominant one that you see among the states arguing is, look, if you were going to change this procedure, what's significant was they changed the regulation to say sex is not just male, female. Sex now includes transgender identity. And as you see from the policy, frankly, transgender identity, or according to the DSM-5, the manual used to make this diagnosis, for juveniles, there's 8 conditions that have to be met in order for what's called gender dysphoria to be the appropriate diagnosis. You have to meet 6 of those 8 criteria, and the condition needs to last for approximately 6 months. It's a highly complicated issue. If you look at the guidance letter simply says that the student themselves can identify this decision. That puts school districts in a very difficult position. The second thing that is troubling about it from our perspective, and this gets a little bit more away from the legal and more from, I guess, what I would call a facial concern, is because we see the faces of young people who are traumatized by sexual assault. According to the U.S. Department of Justice data that they released, 1 out of 4 women will be sexually assaulted by the age of 18. Now, I haven't seen the data to go behind that, but if you use that figure, that means that 25% of the young ladies in our school system have been the victims of sexual assault. They also report a statistic that 23% of those come by individuals 18 or younger. Our concern in the office where we work is we see these young people who are sexually assaulted. Most of those cases are not reported. A large, extent of these sexual assaults are not reported. The other concern is not only are they not reported, but frankly, they are someone that the young person knows. Our concern is when you take this highly complicated issue of gender identity and take this broad policy that says that you open up the facilities to both male and female, you run the risk of re-traumatizing or putting at risk people who have already been traumatized by sexual assault. Not by the transgender student, don't get me wrong. What I'm saying is they're making a big assumption in this particular letter that young people in junior high, particularly young males in junior high and high school, will somehow know how to act appropriately when you have a unisex facility, locker room. Currently, it's my understanding, talking with school districts, is when a transgender student comes forward, what they will do is they will meet with the parent, the care provider, and the child, and they will develop a personalized plan, recognizing the privacy of that child. And they will try to develop a plan that meets those needs. It's a collective effort, but it's also a very private effort. What this does is, as school districts who have attempted to do that now are being told by the U.S. Department of Justice that's not good enough. That's what happened in West Virginia. That's currently the litigation going on in Illinois. That personalized approach is not good enough. It has to be a blanket approach. And so that's why you see the legal challenges. I can't go into detail right now where the Attorney General's office is in that matter, other than to say we're doing a lot of research and we're doing a lot of discussion with other Attorney Generals. And that there was a reason that I have to be guarded about, just because that's the nature of my business. Someone said, why didn't you join Texas? Well, you know, we have to look at the full picture of all things. But I thought Scott did a very good job of just generally telling the obligations. Our concern is that under Title IX, historically Title IX and Title VII have consistently held that the reference to sex was simply male, female. And you've seen in Title VII in an employment context, oftentimes courts, when they evaluate Title IX cases, they will reference Title VII cases in this analysis. And the courts have consistently held that the federal law never intended to have the word sex expand beyond male and female. And in fact, there have been attempts to pass federal legislation to broaden what that definition has looked like, and those have been unsuccessful. So our argument is this issue has been addressed and can continue to be addressed and debated, but that has to happen at the legislative level. It can't be done by a simple redefinition in a guidance letter. And what they did in the guidance letter is they said, we believe sex includes gender identity. Now, the Fourth Circuit Court of Appeals, as you may have heard that case, they did conclude in the state of Virginia that the agency had, the federal agency had the discretion to define sex. We believe that that is that's contrary to what we think a lot of case law would say across the various federal jurisdictions. But that case will most likely be appealed to the U.S. Supreme Court. And the action that was filed by Texas will be eventually addressed by the Fifth Circuit Court of Appeals. So that's kind of how this thing has all come to a point. And I think just simply looking at media statements, it appears pretty clear that this federal, that both the Department of Justice and the Department of Education do intend to go forward, and they have in, as I said, they have in Virginia and they have in Illinois, and they're serious about using Title IX to withhold funding. We have not had that occur yet in Nebraska.
Thank you, Attorney General Peterson. We'll open it up to some questions, if that's all right, if your time still allows.
Yeah, and I will have to be somewhat guarded in giving opinions, in the fact that if you do that, sometimes you get.
Well, we appreciate you being here, and very, very informative, the information that you've shared with us. So, Glenn, you have a question?
Thanks for your time coming over here to
You
tell
bet.
us about this. I was just wondering if you had heard any cases where the current policy of having the local school people meet with the family and work out a personalized plan was not satisfactorily working out.
The Illinois case, and I wish I could give you the site on the Illinois case. It's my understanding that the Illinois case was one in which they tried to give a private plan, and the U.S., the federal agencies came in and said that that was not enough, that it wasn't in compliance. And so that one is currently at the trial court level in federal court in Illinois. The case in Virginia, the young man, it was a young man who they set up a plan, a private plan, and gave him a separate facility, and he claimed that he felt the separate facility was not enough. It isolated him, that it was in violation of Title IX, and so he and through his parents challenged that, and the Court of Appeals recently found that they felt that the determination, he relied upon the determination by the federal agency saying sex allowed him to have access to a unisex facility. And the court came back and said, we agree that the Department of Education has the ability to broadly define sex in this way. So that's the first time that type of decision has come out at a Court of Appeals level.
John?
Thank you, sir, for being here. Very, very grateful. Quick question in regards to funding. Nebraska currently receives just under $400 million a year in federal education funding. If we were in violation or a school was in violation, would it be directed against that particular school if they were not in compliance?
That ventures into the opinion level versus the case level, but I would be inclined to think that calls for an opinion.
Thank you, sir.
Any other questions? Or again, I think, you know, the four main areas that you addressed today were very, very informative, and I think they all are pertinent to us in many respects in the role that we play. I think that your office and the support we receive from your office also is greatly appreciated. We do serve in that, quote, quasi-judicial role, and we rely on the expertise of your office, and it is greatly appreciated in the areas that we currently deal with. And I think your insight helps us in our discussion as we move forward to really think through the balance on these very, very complicated situations and issues, but to rely on the legal expertise in that process as well. We do not have legal expertise as board members, and so we are really dependent upon people such as yourself, our legal staff, and your legal staff to help guide us, and it's greatly appreciated.
Thank you. You know, one thing why I raised the issues of cell phone use, computer usage, internet, human trafficking, and the marijuana issue. Mm-hmm. We obviously know within our school systems the biggest, has been a long-term big problem, is alcohol. Mm-hmm. I think the reason we're highlighting these other ones is because they're fairly new. Mm-hmm. And so there has to be, I think, a lot of education, and we hope our office can provide that based upon some of the difficult things that we see.
Mm-hmm.
Thank you again for being here. And in the 4 different areas, you're continuing to do research in all of these 4 areas. And so if you would keep us in the loop with what you find and keep us current, that helps us immensely. So
You
that
bet.
These kind of things, and I appreciate especially the time, the effort that's going into going out to the schools, because I think everybody does not have any conception of how dangerous some of the activities can be that were just probably casual.
Right.
And then they led to a very serious situation. So if we can be of assistance with that, here I'm volunteering services from the department, but it seems to me that any effort we make to get this information out is needed.
I appreciate
So-
that.
Commissioner?
Yeah, and I would just add to that, I do know, by the way, we are engaged in sort of those conversations, and I believe the Attorney General, and I thank the Attorney General actually for being very visible with schools and school organizations so far, and I appreciate you being here today too, so I don't want to leave that without being said.
You bet. Thank you.
Thank you. And I think we will take a short break as we transition into our agenda again. So about 5 minute. I may need guidance on timing with this.
Legal opinions on that?
State Board will come back from break and continue on item 3, Commissioner's Report and Agenda Overview. I believe you're at item 2, Report on Rules, Commissioner?
Yeah. So on here is our regular kind of update of rules. First of all, there's several that have, I believe, gone through the process, and you can see those on the list. I'll just quickly read through them. Rule 1 was approved by the Governor and Secretary of State on the 12th of May, making it effective in May as well. Rule 13, I'll just run through them quick. Rule 13, Rule 2, Rule 51, and Rule 83. Missed one, Rule 24. So all of those that have actually work that you advanced to a review for the Attorney General's office and then to the Governor, those are all the ones that were done. A lot of thanks to staff in those offices that get these things accomplished for us too. We don't find staff in state government that are pretty well occupied with lots of things all the time, and so those are an important aspect of that. The other one that I guess it's listed somewhat separately on the agenda is an update on Rule 4, and given the while the Attorney General was here today, I was actually handed the courtesy review on Rule 4. Rule 4 being the textbook loan program, the conversations that we've had around that. As you might remember, last time I updated you a little bit about that process. We had submitted something for the Attorney General's courtesy review to make sure that language that had been kind of bounced around between the Nebraska Catholic Conference and us, looking for us, kind of a solution of how do we actually move forward in ensuring that the changing nature of textbooks and digital materials all come together, and what kind of guidance could we have to go ahead and have a rule put forth. So I would just tell you, just in the very, very quick read of this, that it looks like language that we've submitted would be at least appropriate. They don't give us a definite answer ever in this type of courtesy review. However, it would put us in a position to put language together, finalize that language, issue for a hearing, and have that hearing out in the next 30 days. My intention, again, as I mentioned last time, that we would actually have something back for your consideration in August, so we can vote on that and move that forward. I wanted to kind of highlight and thank Greg Schleppenbach and Jim Cunningham. Greg is on his way to DC one more time, we're on his way to DC to accept another position, and so he is in trade. And I think Jim is in place for this moment in time. I don't know if you guys want to come up and just say if you have any thoughts. Otherwise I can keep talking. They don't have any thoughts. I mean, no. And John knows I can keep talking, so
Yeah.
he's convinced of that.
We might get the rest of the story.
Well, that's true. But I do appreciate very much Greg and Jim spending time on the phone with me over the last couple weeks, talking about this, resolving a bit of the concerns, making sure that we're somewhat on path. We'll go through this together is what I would tell them, and we'll come up with language that we think would be appropriate for hearing. One of the things we also want to make very clear is however we do that all of the information that we share with she's going to make you come up one way or the information
They're thinking about it.
information that we share with our public schools that can apply for grants for these textbooks, that is very clear what they're able to do. So I feel very good about that process, and I do just thank you for your efforts, and we'll continue that work and wrap that up too. So,
Mr. Commissioner, you say there'll be another hearing probably within 30 days.
yeah.
I just like to suggest that we do our best to coordinate these hearings so that, given the huge turnout at the last set of hearings, I don't think we all have to be at that hearing. And, maybe one person or two people from the board, rather than having the expense of sending people and paying mileage, blah, 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 blah. Thank you.
Yeah, you bet.
And I just want to comment, it does have to be, notice has to be put out, and then a 30-day
30 days
notice.
once we
So
get the notice out.
it actually won't be within 30 days. It'll probably be maybe
Probably
5 to
the last
6
couple
weeks,
is
whatever,
already
yeah.
before we're done, yeah.
So, go ahead.
I was just wondering if we could get this attached to our agendas here.
So we will talk about that. It's actually legal advice that's given to us. Once I get the approval from, Scott back here, this guy back here, So, no, but I think that's probably going to be appropriate. I just want to make sure that you had it literally hot off the press, so.
All right, any other questions?
Congratulations on the new appointment.
All right, continuing on with the commissioner's agenda, I think item 3, board priorities and policy research.
And I am going to bring Donlin Rice up for a little bit of that conversation. I don't know that she has a lot.
say, I don't know that I can come on. That's okay.
One of the things I will tell you is we continue to do our work on strategic planning. You can obviously see that work coming together, Donlin's efforts on that. Also kind of our attention to NASB and other policy work going on. It's a very unique moment in time, and so if there's not a lot,
I
that's
don't
fine.
really have a lot, but I do want to thank you for your ongoing support of the strategic planning process. I thought this morning we've got a lot of things to think about, but we're making progress. Going to be continuing to work on it over the next couple of months. One of the things Dr. Bloomstead mentioned, we're trying to think about all of our different threads of work that we have going on now and making sure that we're working together with different things. For instance, if you take content standards, well, they're mentioned in ESSA, they're mentioned in our strategic plan, but we're also doing standards. So sometimes we have something that's actually a project or has kind of a finite timeline, and then others, like our ongoing programs, they intersect both ways. So we're trying to make sense out of all of that and coordinate all that, so that is exciting for me. Also, I am in a new location. I'm directly behind the wall there and right next to Dr. Swisher, so I think Commissioner can keep an eye on me now, so anyway.
Thank you, Donlin.
thank you.
Any questions? Okay, if not, we will, anything else, Commissioner? If not, we'll move on to item 4.
That's all.
Okay, we'll move on to item 4, discussion of action items. Our first item is to discuss a proposed revision to Rule 25, 92 NAC 25 regulations governing the Excellence in Teaching Act. Karen Bowler? And
not
Sharon
Bueller.
Cott. Hi. Welcome.
Thank you. Of course, I'm Sharon Cott, and it is my pleasure to introduce you to Karen Buller, who truly is the manager of the Rule 25 piece. She told me I had to be the one to talk, and I do everything that Karen says because it scares me to think that she would not be around to manage this program. So I do what I need to do. As you will see from the rationale items, this really is about updating Rule 25, which is the Excellence in Teaching Act. And the changes were essentially to incorporate some statutory changes that were presented from the legislature. One has to do with incorporating the ability to use the funds to support individuals who are seeking to add an endorsement in a shortage area. Prior to this, it had to be a master's program, so it's opened up options a bit. And then the second one was to incorporate changes regarding the loan forgiveness timeline. What it essentially does is it creates a situation where it will take longer for people to achieve loan forgiveness under the new statutory language. Would take just a moment to point out to you the second page of your agenda items to give you some sense of what this program is about. It's been around now for several years. We're at a $1.2 million annual allocation that is split between initial certification programs, in other words, to individuals seeking to become teachers, split with individuals who are seeking to advance professionally in their career. Over the course of time, Karen, well, there's been one other person, but for the most part, Karen has issued well over 3,500 loans, forgivable loans through this program, and right now has about 2,000 active people in the file folders, literally, they're in the file folders, who are still in the program, either working through loan forgiveness or have just been authorized to receive the funds. So it is a very time-consuming process in that we will track people anywhere from 2 to 5 to 15 years, depending upon the pathway that they take. If you have questions, we'll certainly be prepared to answer those. Otherwise, tomorrow we will be asking you to approve the changes to Rule 25.
John?
Sure, just a quick question if I may. How many teachers are put into this program every year, would you say? How many submit applications?
The current teachers or the initial?
The initial,
I think it's initial is usually about 135.
a year, okay.
Yeah, that's limited by the amount of money that we have.
We believe that there's a demand that's greater than the resources. However, the way that the program is set up, we don't necessarily see that demand in that applications come through institutions before they get to us. So some of the demand is stopped at the institution level. The first year, we were not smart enough to do that, and we took all the applications in, and it was absolutely hideous for about a week because
And that was before I
it's
started.
so huge. Yeah, we learned on that one.
That's why I started.
So do teachers have to fall within a certain salary range to qualify, or, and I think that's great, so they're not like Pell Grant type restrictions.
no.
That's great. And is there a payback, or they don't have to pay back, do they? So it's longer, is there a time frame to complete their program?
That's right, it's time frame to complete. If they stop teaching in Nebraska or if they don't complete their program, they do have to repay the
Okay.
funds that they received. So we do have a number of them in repayment as well.
Two-year program to complete or something like that?
Yeah, we give
their
them
degree.
5 years to complete their program.
Oh, that's good.
So, yeah.
Do it over the
And that's
summers.
why, then when you say 5 years to complete your program, and then you have to teach for 2 years, and then you have to begin teaching it off, that's where it kind of begins to stretch out to keep track of people.
And in your materials, just real quickly, that if you look at the AETP program, which is the initial, according to Karen's information, of all those forgivable loans that have been awarded, we have about 15% that didn't make the forgiveness requirements and are in a repayment process. For the EETP, which are those individuals who are certified teachers seeking to advance the profession, we only have about 5% that are in repayment because they did not meet the provisions for forgiveness.
Any other questions? Thank you, Sharon. Thank you, Karen. We'll move on to item 2, discuss revisions in the attached special purpose agreements for the accredited special purpose schools having waivers under the provisions of Rule 10-013.04. Frida, how are you?
I am good, thank you. Well, I'm Frida Lang from Accreditation, and this particular item is in regarding to special purpose agreements that we have for our special purpose schools. And maybe to give you a little context here, first of all, tomorrow we're going to ask you to approve those revisions that were attached. And at this point, this time, they are pretty minor compared to some, after some revisions of Rule 10, we always do this kind of update so that the special purpose agreements are current. You probably are aware that we have at this point in time 5 special purpose schools in Nebraska, and those include Geneva North, Kearney West, Nebraska Correctional Youth Facility in Omaha, the Pine Ridge Job Corps, and the University of Nebraska. It's pretty obvious, University of Nebraska High School. It's pretty obvious that those particular institutions do not or cannot operate under the same provisions as all of our public schools. And therefore, the special purpose agreements do contain some items that we can waive. We cannot waive anything statutorily, but that is statute. But the rule provisions we can if it is in the best interests of the students for their education. For instance, at the NCYF, the Nebraska prison, where we have, I think, approximately 78 students that are at the high school level who have been convicted of felonies, and to have access to the internet is not what is in their best interest, or our best interest probably. So that would be some of the provisions that we may see that are waived, that they do not have to have some of the technology that we want to see in our public schools. When you look at the schools that we have, many of them have been in existence much longer than the State Department has been in existence. In fact, Kearney West came into existence for both boys and girls in 1881. That was followed by Geneva, which came into existence, and then they separated. The boys stayed at Kearney, the girls were placed in Geneva, and that went into existence in 1892. Just a little bit of history for you, which I think is fascinating. But then we also have the University of Nebraska High School, and that was actually a correspondence school that went into existence in 1929. So they have been there for quite a while. The Pine Ridge Job Corps came into existence in 1965 when Lyndon Johnson was president. And currently there's 125 job corps across the United States, of which we have the one in Nebraska. And then our NCYF is our newest, and it came into existence in 2008. So there's a little background on those schools. As you look at the special purpose agreements, the main thing that we're doing on all 5 is just an alignment of the date with the current Rule 10. The other change is the University of Nebraska High School, and it was simply a change in the name, because it used to be the University of Nebraska Independent Study High School. Now it is just simply University of Nebraska High School. So that is one change. The other change that would be maybe considered major, and that's for NCYF, and this was done at the request of the school itself. That we had a waiver in there regarding PE, and they have asked that be reinstated so that they have a little more control over the fact that there is PE on a very regular basis under the conditions that we have set for our public schools, finding it's much easier to work with the young men when they have had that in the school day. So anyway, that will be the major revision. So that's what we're doing, asking you to approve tomorrow.
So any questions on the special purpose schools? If you want to just continue on then.
Okay.
Rita?
The next thing we're going to ask you to do is to accredit the schools that were on the attached list for the 2016-17 school year in accordance with Rule 10. All the public schools in Nebraska are by statute required to be accredited. They have all submitted a statement of assurance indicating compliance, and in some cases they may note an area of non-compliance. For instance, they may have some teachers that are teaching out of their endorsed area in a greater percentage than what we require in statute. We give them a certain period of time to correct that, as long as it's not statute. And so there are several schools who have a written plan in place to correct that violation. If they do not within the year, then they would be brought forward to the State Accreditation Committee next year for the possibility of being placed on probation. But at this point in time, all the statement of assurances are indicating they either have a plan or they are in compliance with Rule 10. In addition to that, we have checked the records that come into the State Department, and we also do random visits to our, to all of our schools, whether it's the non-public, the public, trying to get to every school within, say, a 7-year time period. And to see if what they are reporting on the statement of assurance aligns with what is actually found when we go on a visit. All of these schools have been taken to the State Accreditation Committee, and they are they recommended that they be approved for the 2016-17 school year. This includes 245 public school districts, 80, now this is growing, 80 of our non-publics who elect to be accredited. They have to be approved, but they have elected to go to meet the requirements of Rule 10. And then our 5 special purpose schools.
Any questions? If not, Frida?
All
I
right.
think you have one
One
more
more.
item.
And this one, tomorrow, we'll ask you to approve the following 2 schools: Nebraska Christian Schools in Central City, and then the Lutheran High Northeast in Norfolk, to move to accredited status for the next school year.
Great. Any questions? Thank you, Frida. Next, we'll move on to item 5, board member request for resolution on Title IX. I'll turn it over to Pat McPherson.
Well, I believe you have the resolution attached, and I intend to introduce that tomorrow and hope that I will get a second and we'll have a discussion on it. I'd just say that today I'd say that this is a timely issue. I'd say that this is not a policy issue. It's not something that I believe should wait till August or later to be discussed. I think it's really a sense of the board resolution. I don't believe it has any potential financial impact on the board, on the department, or on the state. It's just a way, and I would go on to say that I believe this is a local control issue. Just as I believe that Bellevue has the right to decide whether they're going to have a transgender or restrooms or facilities in their sports areas, I believe this is an issue that is best addressed at the local level, and I think this is a total overreach by the federal government. I thought that the Attorney General did a very good job of referencing our state law and referencing the requirements under Title IX to promulgate such a resolution if you happen to be the federal government, and those have not been followed. So I'll introduce this tomorrow, and hopefully, like I say, I'll have a second and maybe further discussion. Thank you.
Comments, discussion? Well, I will make a couple of comments regarding this proposed resolution. I do think there are things that we need to do our own due diligence. And I believe in developing a resolution and having this kind of conversation is important, that we have done it in a process of a committee. Typically, we've used policy committee for resolutions because it gives 4 board members the chance to be involved, the chance to have input. We have a chance to have legal counsel and input in the process, which I think is an important protection for us and a part of our due diligence. I do believe it's important that we not overreact or overreach as we've seen done at a federal level. I think, again, that's an important consideration we should take when we have this discussion. I do not think that timeliness should be a reason because others have made statements that we should think that we need to react on a timely perspective. I think we should be thoughtful. I think we should be thoughtful. We have responsibilities to see that we're following the law. I greatly appreciate the Attorney General here today and the presentation by Scott. I think for me brought some ahas forward. That first of all, this is a very, very complicated and sensitive issue. I concur that it's dealt with and should be at the local level, and that's an important part of the process. But I think what was pointed out today, we do have some responsibility as well as it relates to our Perkins funding. And understanding what our responsibility is, I think, is important, and what occurs typically at a committee level before something would come forward. So I just want to go on record why I think it's important that we have a thorough discussion. And typically trying to have amendments or rewrite a resolution at a board meeting is a difficult thing to do. And I just wanted to be sure that there's an understanding of why I think it's important that we do our due diligence in this process. Lily?
I found it most interesting what the Attorney General had to say, and my comment to him was that we would like, as a board, at least from my point of view, we'd like to be kept in the loop in terms of the research that they're doing in these subject areas, all 4 areas which he addressed. And that the note that I jotted down is that there's no current real knowledge from their office with a position one way or the other regarding this issue. And so knowing that, or that's how I understood what he had to say, it would seem to me that we would be trying to supersede what work they have yet to do, and that it would make a lot of sense to follow the directives that would come from the AG's office, and that could very well, in process with their research, come forward eventually. It's just not there yet. Secondly, we have a procedure we follow when we do any type of major decision, and it's through our policy committee. We do resolutions through the policy committee, and it seems like we should follow our procedures that we have in place.
Glenn?
Well, I thought the Attorney General's information was very informative. I was struck by the fact that it used to take 6 out of 8 symptoms over a period of 6 months before they could identify them as transgendered, and now it's up to the self-identification of the student. It seems to me like this is going to open up teachers and schools to all sorts of pranks, and it's going to be hard to enforce this transgender bathroom policy from the federal government without letting a lot of people that really shouldn't be in the girls' restroom in there. So in order to act quickly and give some guidance to the schools in the state before August, they need to be acting on this. I would like to see us move on this tomorrow. Thank you.
Thank you, Glenn. And I do think it's important that when we make sure we give guidance, that we're giving guidance that is legal, and that we've done our due diligence on that guidance, whether it be through resolution, through policy, that we've done our homework in the process. And that I think is just a part of our conversation as we have. Any other comments?
Well,
Pat?
since you, I get a rebuttal now, right?
Sure, you bet. That's why we're in the work session. We
No,
can have our conversation, absolutely.
And again, I see this as a sense of the board. We're not going to endanger Perkins funding by passing this. We're not asking anybody to do anything or not do anything. We're trying, I'm trying to be sensitive to 245 school districts that are up in the air about this. They've got to make their own decisions about this. I believe in local control, and the resolution clearly states that they need to act in their best interest for what the parents and the board members in those districts want to do. This is not, but I also respect the fact that we've got an awful lot of people that are confused by this, a lot of parents that are very unhappy about it, a lot of children that may be threatened by it. And I don't think it's inappropriate for this board to pass a resolution, which I would hope that somebody at the national level would see and say at least somebody speaking out against this overreach of government and not following their own policies that are part of Title IX. So that's where I'm coming from. I respect what you have to say. I do not believe that I believe that it needs to have an answer now rather than in August, and we'll talk about it tomorrow, I guess.
And we will. We can continue to talk some today as well as tomorrow. And I think that's where a resolution should be written, that we know it embraces the elements that we've just had the discussion on. When it maybe steps outside of that authority and into other areas that may be somewhat subjective, I think we're not doing our due diligence. And to go through a process of starting to rewrite this amendment to better provide guidance, I think is what we have committees to do. So, any other comments or questions? We will have this on the agenda tomorrow, and we'll continue our discussion at that time. So let's move on to, I think that's the end of our action items, so we'll move on to item 5, committee reports and other items for discussion. And our first item is AQuest, and that is update on priority schools. Commissioner.
Yeah, well, I think I'll actually have Kathy Kennedy and Sue Anderson go ahead and come up. I'm going to, first of all, as we did our work in the committee, we want to give you a little bit of an update to the full board around our progress and our work on priority schools. And I think when you talk about our work in priority schools, the reality is it's the Department of Education working very closely with places on their improvement. And it's Dr. Friesen that on occasion reminds me that we're talking about places that need improvement, not places that need necessarily continuous improvement, because that would assume that everything's there that they would be able to move forward. And so our work, and I know what we presented to you, gave you a little bit of a sense of a timeline of those three schools, so Druid Hill and Omaha Public Schools, Santee Public Schools, and Loup County Public Schools. I've been very impressed with our team that's done this work. It's a substantial amount of effort that has gone into each particular place. I wanted to have and introduce, I guess I know you've all met Kathy Kennedy. Kathy's doing some work in a consulting role with us. I think she does a very nice job of outlining kind of our main themes of our diagnostic work within these schools, and I think Sue Anderson can kind of help provide some of our next steps. We know that we'll be bringing back to you essentially plans for your adoption at the August meeting. So I'll turn it over to them, and I want to just give a real quick overview.
Good afternoon, board members. Thank you for letting me be a part of your meeting, and I echo the commissioner's remarks regarding the passion and helpfulness of the NDE staff, including the commissioner himself and the deputy, who have really had firsthand experience and hands-on with this approach. So just congratulations for having the right people at the table to do this work that I think will pay big dividends to you as a state board in the long run. We'll at least learn from the processes that we create so that we can replicate those other places. In my role as the consultant, I have worked for the past year with Druid Hill in the Omaha Public Schools on exactly what you have identified as a need for a state board. So it's great to see the two boards really having the same type of vision for their schools and their school district. In that process, and in the process with the other two schools, the pre-K-12 schools, I have completed a diagnostic review of the school in 3 areas. The first area is clear, compelling direction, which really focuses on the vision of the school, the core values, the mission, and not just having a mission statement, but having a sense of mission of what the purpose of the school is from a student level, a staff level, administrations, parents, community members, as well as the Board of Education. You know, what is that sense of mission for creating an environment where students can be successful academically, socially, emotionally, physically. It's beyond just test scores. It's really looking at overall direction of how the school prepares the students for the world of work, or to pursue college education or serve in the military, whatever the dreams of the children of that particular school are. In addition to that, I took a look at the staff and student culture to determine if the schools were places where students wanted to attend, the staff wanted to be there to teach the students, and have that sense of urgency around educating students and meeting the needs of the children there. And then I also, in addition to that, with staff and student culture, is it a place where parents want to send their students to learn and they feel safe in doing so? And then the final area was instructional leadership capacity. One of the pieces of research that I looked at is Katie Haycock's research around teacher efficacy. And one of the things that we know about teacher efficacy is that if teachers feel good about their role in the school and what they're doing in the school, that student achievement soars. So actually determining how we are developing the talents of teachers within these 3 schools, as well as providing support to them with curriculum alignment to the Nebraska state standards. Also, their lesson planning processes, are they adding rigor to the curriculum and differentiating instruction for students who need it most on both the ends of the spectrum, not just teaching to the middle, but most importantly, getting students ready for the next level of learning. So if I'm a 2nd grader, am I being prepared to learn as a 3rd grader? Am I being prepared as a 9th grader to be a student that can master the 10th grade curriculum? So it's looking at really my diagnostic review looked at all of those areas. For the purpose of informing their progress plan. And that was just one measure that really is going to inform their progress plan. So I would say my review is more of a qualitative review because I interviewed staff members, I interviewed students, had wonderful conversations with elementary, middle, and high school students in 2 of the schools, and then elementary students at Druid Hill. Also interviewed parents, community members, board members, anybody that we could get in to come talk to us about what was good about the school and what were the things that we needed to do to improve in the school. We wanted to hear those voices of the stakeholders. In addition to that, during the review, we visited classrooms and walked with the principals of the schools and walked out in the hallway and said, what are you seeing? How are you going to coach this teacher who may have some deficiencies, but how are we going to coach those talents that the teachers bring to the table to help them to be even more successful with students to build their capacity? So using the qualitative measures as well as the quantitative measures that they already have in the school, hopefully that will help them move forward with their progress planning to have goals that are attainable, their goals that are specific, and that will help them get out of priority status quickly.
So I'm just going to briefly overview next steps. As you know from our sessions this morning, we are in the stage right now of beginning to draft the progress plans with the schools. We have initial drafts of improvement goals and improvement strategies for each of the 3 schools. And so we will now use the month of June and into July to continue to finalize those plans. We will have communications with the schools as we continue to work on finalizing those plans so that they feel they are informed and still have their voice around the table as we are working out the best plans for each of those schools. As you know, August will be the board meeting at which the schools and we will present the progress plans for your approval. And then once their plans are approved, and I think you saw some examples of what the plans will likely look like today, once those plans are approved, then that will initiate a whole other phase of our work to continue to work with those schools and support them in the implementation of their plans. And as we discussed in one of the domain meetings this morning, building into the plans some steps for bringing some regular updates to you throughout the year so that you can be informed about exactly what's happening in the schools and what progress they are making. So I would say generally those are our next steps, and if you have some additional questions, we'd be happy to try to answer them.
Are there any questions? Lily?
Thank you for being here to give us this update and something that I don't see here, and maybe it's not within the realm of what you look into, but are there ever questions asked about the finances of the school? Could they be in need of some additional financing? I don't see that in the report as to something you ever ask them about. Maybe it's not something we can do something about, and so I just wondered, for example, you say that you check to see if appropriate technology is available for
Yes,
use
ma'am.
by the teachers in school, but that costs money too.
Correct.
So could there be a situation where they want to do more but are somewhat limited by their finances?
That's a wonderful question, and one of the things that the commissioner has asked us to do is to look at goals for the board, the local boards as well. And so financial components, certain goals for finances would be in that particular realm of the progress plan. I believe that's where it fits best. And I think that it's really up to the school to let us know in the progress plan under resources, what are the things that they need. And I also believe that when they do their updates to their local school board as well as this school board, that there can be a time where they ask for additional resources, and those could be human capital or they could be monetary resources. Just really depends, because they are going to need resources.
And can I address that just to a certain extent? One of the roles, as we've kind of tried to build the model around how we work with priority schools, is I spend time with the elected boards and the administration largely. That's where I spend my time and energy in thinking through what conversations need to be had. And so when things are surfacing that are around resources, sometimes it's not just about more, but how we decide to deploy resources within schools, and offering that as recommendations, and in particular appreciate the recognition of boards sometimes need guidance, right, relative to what direction we're going. We want that system to work. Not terribly different than our conversations around our own strategic planning. We are finding that schools where systems aren't working, there's a whole bunch of data elements, there's a whole bunch of things you can observe that aren't working right. And when it doesn't work right, that has a negative impact on the students' ability to perform in a regular academic setting. But we see all those things coming together. I think it's a quite remarkable process. I don't know that you see these types of things nationally. Kathy, I know, works nationally. The fact of the matter is we're trying to build a model that helps these three schools, as well as if you remember those categories that we identified, all the schools that needs improvement there, plus provides a roadmap for how schools generally get their improvement strategies done. And I'll throw one more in, our work. What do we need to commit relative to improving these places to move us forward? And I think you see that coming together with these plans. And again, it's a very unique time because we're doing that work from a state level. But I see this coming up and being absolutely critical that system interaction works well together. And so I really thank Sue and Kathy and Dr. Fry, and I'm going to forget people when I do this. I see all sorts of people that are important. By the way, I noticed back here, by the way, you have Tony Hoffman, that is been a principal at Santee, sitting in the room observing this conversation. Probably his first time to appear at a board meeting besides the Attorney General today. So maybe he's the bane. I don't know. But the reality for us is it's about leadership development. It's about making the system work. We're bringing that together. We've been very, very active, very, very active on these plans, and I appreciate you listening and offering your comments today and helping guide us, because we want that in August to be something not only the schools are proud of, the department's proud of, that you're proud of those efforts, and that we can measure our progress along the way. So.
Well, I'm pleased that they go out and elicit the input from the stakeholders, the parents and community, because that I would suspect they're very interested in trying to help and to have their voices heard.
You bet.
That's
They were
time consuming,
appreciative.
it takes extra effort, but in the long run, it's what is most valuable to do.
That's how change occurs, if you have stakeholder voice, for sure.
Any other questions or comments?
I appreciate the update today, and I appreciate your responsiveness. I had a couple thoughts that I shared with you that you seem very willing to adapt to, and And I think you're off to a great start, so thank you.
Thank you. Keep them coming.
There's no other questions? Is there anything else on AQUES, Commissioner? Oh, then we'll
Thank
move
you.
on. Thank you very much for being here and for the update.
You bet.
Thanks.
Thank you.
Next, we'll move on to item 2, which is the teaching and learning domain reports. And we've got a couple of things we'll cover in that report. Maureen Nichols was not here, so I tried to chair that particular meeting. We had some update on the college and career ready standards. I think, Glenn, did you have some things you want to share on that?
Yes, I do.
Thank you.
So, right now they're working on PE standards. They want to get a draft to us in August and then put it up for our approval in September. And then the science standards, the steering group met on Tuesday. And these are people that have already adopted the next generation science standards. The writing team is going to meet in October, and all that work is proceeding on schedule.
Thank you. Any questions of Glenn? If not, we'll move on to the assessment tenant report. And with that, we've got a couple of things. I'm going to turn over to the commissioner, and I think Valerie first. We have 2 items in this report that will be on our action items tomorrow. So those 2 items, as we move forward, we'll talk about, and they'll reference action item 7.3 and action item 7.4 we will be covering in this update on assessment, talking a little bit about what our plans are for 2016-17, and then really talking just briefly some thoughts to start us thinking about 2017 and beyond. So with that, I'll turn over to Commissioner Valerie.
Yeah, and I'll have Valerie go ahead and come up. One of the things I'll try to set a bit of the context. If you think back through the history with our DRC contract, it was actually issued as an RFP, and we entered into an agreement for 5 years. So really, what we're talking about today is continuing something that we've from a contract perspective, continuing something in that process. Annually, we would come back and revise that contract. As you know, we discussed, the reality for us is this would be the 4th year of what normally would be 5 years. We've made the decision that we will issue an RFP for beyond the upcoming year, right? That we will go through a process and do that. Valerie, I know, can highlight some of these things, but by the fact that we're making a decision about what we are going to do with DRC, we're also making some decisions about other steps that we're going to address for 2016-17 assessment. And as Rachel mentioned, we can kind of also include a little in our conversation about beyond the 2016-17 year. But with that, hopefully I set you up. I was the opening act for you. Since Scott has given us that analogy.
Thank you. I'm Valerie Foy. I'm Director of Statewide Assessment, and none of my team are with me because they're all doing different things. Jeremy's running an item writing workshop, and John's working on some finances. So I have brought into you the proposed Data Recognition Corporation contract for 2016-17, and the motion for tomorrow that this is preceding is listed at the top. It's to grant the Commissioner the authority to contract with Data Recognition Corporation for delivery of statewide assessment for 2016-17 as presented for grades 3 through 8, NISA Reading, English Language Arts, Math, and Science, and to exclude options for NISA Writing at grades 4, 8, and 11, and NISA Reading, Math, and Science at grade 11. So I'm going to go over what the contract includes, and then at the end, I'm going to go over what the contract does not include and the rationale behind that. And so this is to talk about what we are doing in this transition year as we move forward with envisioning perhaps a different concept of assessment in Nebraska. So if you look at the document I gave you, the first 2 pages of it cover what is included in this contract. So it's the general pieces of the assessment contract that you've seen before you year after year. There's project management and planning, the assessment system development, delivery. The gray bars just give you the major areas of the assessment. And if you go to the second page and go down toward the bottom, you will find a dark blue line, And on that dark blue line are the total base costs. And what that means is that this is going to cover NISA reading and math for grades 3 through 8, science for grades 5 and 8. And these are base costs. The reason it's called that is because they were included in the original scope. And that's why they're called your base contract costs. Then, in addition, we have asked for some scope additions. They're very necessary ones for us to get through this year. I would be happy to answer any questions, but obviously the Braille transition, the U.S. is transitioning to a new type of Braille language, and so we are providing for that in this contract. So if we need to provide any tests, assessments in that new Braille, we need to include the cost to do that. So the total base costs plus the total scope addition costs are what we're bringing before you. And if you'll turn to page 3, you will find your totals there. So our total base costs of $4.2 million and then our scope additions of $90,000 come up to a $4.3 million contract. That's in contrast to a $7.2 million contract that was the contract that was approved in 15-16. So this is a considerably different contract. Our funding sources for that are the special education state funds because they fund the alternate assessment, the federal funds, and the state funds. And that does lead me to say it is also included in this contract to continue to offer alternate assessment at grades 3 through 8 and 11 because those are not discluded. They're included in here, and they are in the listings that are done. So now I want to talk about what's not included. So if you turn to page 4 with me, the first thing I have listed there is the grade 11 reading, math, and science. And as you know, LB 930 did pass this year, and with that, it established the administration of a standard college admission test at the high school by 2017-18. So we're in 15-16, 17-18 is another year off. So we had this transition year in between, and we had to determine what we were going to do for that 11th grade class. Were we going to continue with a transitional year of NISA or possibly move to a college entrance exam for this year? When we looked at the different options that were available to this, and we've discussed these, we've done surveys on this, the commissioner ran a survey, and I have also talked to the Assessment and Accountability Advisory Group. The thing about trying to do one more year of NISA at grade 11 when we're going to switch in the following year is that creates a certain amount of chaos, because there are changes in the 11th grade assessment that have to be done. We would have to do standard setting. They would have to do the new item types and have them operational. And it seems that that's somewhat a lack of waste of resources to aim toward that and then the following year to switch to the college admission exam. So for that reason, we are in the process of writing a request for proposal to initiate a college entrance exam for the 2016-17 school year. Therefore, we do not need the NISA 11th grade assessment. The NISA writing at grades 4, 8, and 11 are also not included here. This was not a decision lightly made. I do think grades 8 and 11 were somewhat of a foregone conclusion. There has been a real loss of commitment to that in the state of Nebraska because of the technology issues that we've had. And when we have to continually release our scores with caveats that that there may be questionable scores here because of technology issues, it is discouraging for our educators who have worked so hard in grades 8 and 11 to bring their bring those standards to their students and to improve their writing. So that was a big factor in the grades 8 and 11, the major one. So then we had to decide what to do about grade 4. Again, this I think is the one that was least lightly done. We have really put a lot of research in this. We ran a survey that we released to Nebraska superintendents, elementary principals and to teachers. We also, then I took the results of that survey and I presented them at the Assessment and Accountability Advisory. And here's what we found out through those processes. We don't really have a mandate one way or the other that we can get as a commitment. What you will see if you looked at the exact results of this is there's pretty much a split out there. Some educators want to keep it, some educators are really willing to move on. And here's the main piece about it. The NISA writing test at grade 4 is not aligned to the Nebraska State ELA College and Career Ready standards. It is not aligned to those. And yet, we are instituting an English Language Arts test that is aligned to those standards and in fact includes a writing task on it for grades 5 through 8. And so for that reason, we made the determination that we offer to you to not include that NISA writing at grades 4, 8, or 11 on the DRC contract. The next ones really, they're listed separately, but I'm just going to talk about them together. We're not going to field test the text-dependent analysis at grades 5 through 8 next year. If we did, our students would have to do an operational text-dependent analysis. That takes them 30 to 60 minutes. And they would have to do a field test of a different rendition of the same item, another 30 to 60 minutes. We field tested this year 5 different text-dependent analysis at each grade in 5 through 8, and we have good results from those. We do not need to run a field test this year, and so that wouldn't be productive, and it wouldn't be a good use of our schools and our students and our teachers' time to do so. So that's why we made that decision at 5 through 8. At grade 3 and 4, the decision was slightly different. We did not run a field test this year. We ran a pilot. But we do feel at this time we do not have enough research to move forward and run a field test at grades 3 and 4. We have several questions around this. We are questioning whether our students are best served by doing this writing task, paper pencil, or online. And there are good reasons to go either way on that. But there isn't a lot of research yet on student success at the younger grades and taking an open-ended assessment like a writing assessment online. Now, I do think there's a great deal of research pending, very shortly going to come out, because the 2 national consortia did run this type of testing online, and all of the research articles I found said they're just really excited to get the results of that this year, and so are we. And so we think that would really better inform our future decisions to do the right things for our 3rd and 4th grade students. So for those reasons, we are not going to include the 3rd and 4th grade a field test for the TDA. Finally, my very last piece of information on page 5 gives the total cost of all of the options that we have chosen not to exercise in the DRC contract, and that's $1.3 million. And so I turn it over to you.
Any questions? Glenn, and then Pat.
And so Valerie, the good news is we're going to shorten our testing window, right?
Yes, thank you for reminding me of that. So there are 2 things that you remind me of. One is we believe by doing the text-dependent analysis at grades 5 through 8, we do fulfill our requirement to test writing at a single grade, as we are required to do by state statute. And then we also, I'm sorry, Glenn, what was the second thing you asked me? I apologize.
Because we're eliminating writing.
Oh,
we're
we are
shortening our
eliminating
testing.
writing. It's a 3-week window, and it runs from the last 2 weeks in January to the first week in February, and that's 3 weeks. Our reading, math, science window starts the last week in March through the first week in May, and they're very separate. They're very separate windows, and we will totally eliminate the January and February window by not running the NISA writing at grades 4, 8, or 11, but we will be testing writing on the new ELA exam that will run from the last week in March to the first week in May. So we definitely will reduce testing time by doing this.
Pat?
I've had several questions about the 11th grade.
Okay.
And they involve selection, and you mentioned putting out an RFP. The question has been, is has there been discussion of using more than one college entrance test, or will it be just one?
I like it when they all look at me.
What are you talking about?
Well, and actually, and we have talked about it in the assessment tenant committee as well. So obviously, where we're looking at this upcoming year is very much this transition year. The LB 930 that says by 17-18 we will have a college entrance exam. We have had conversations with, and I have had personally conversations with the community colleges, the chief academic officers of the community colleges. One of the interesting things that we had discussed, I think, at our last meeting, our last month's meeting, is going about issuing an RFP for a college entrance exam. But we did talk that ESSA and other things are kind of moving down this path where it's possible to have more than one assessment at high school. We believe that the focus of high school assessment is really moving us, transitioning us to a focus on the student's future. So I think we believe that pretty strongly as a board. I've heard that from you several times in several different ways. But we believe it would be possible this next year. Number one, we issue the RFP. We'll bring a recommendation. Most likely, I think we're in plans to be able to bring you something in August and that you would vote on in September relative to the college entrance test. We also believe that we can establish a relationship with the community colleges, as they have with AccuPlacer, the product that they currently use. In an agreement with them, they're able to offer that assessment as well at high school, and for the purposes generally around dual credit. That's why they offer that to students. So an agreement between those would give us at least that dynamic of an option for certain students. One of our concerns, whether it's with other college entrance tests, exams, they usually have a very short window. So the window is usually offer it once and offer a makeup date. So some of our concern was some students might not be able to meet that window for a lot of different reasons. We believe that underneath the community college's agreement with AccuPlacer, that it's possible that some students that might miss that window otherwise would be able to take that through that environment as well. So there's some benefits to us in thinking through that. Given the transition year, it gives us a chance to explore those options and see what's there. We think that will meet our requirements as we look at state law. We know that every transition presents certain challenges in making sure that we're meeting those requirements. But I believe we're at this point in time where it's really about the students that are in front of us, right? The students' opportunities for their future. If we can make that about the students, if we can make that about the students' future and about, I would say, actually a student choice around those assessments, would position us far better than as a state, and probably much more aligned with the future of ESSA. At a moment in time that we're going to be rolling that out, other states are still just talking about it. I think we'll be rolling out conversations that put us down that path of how that ties together in the long run. So,
Well, the fact that this discussion is going on is going to make one of my curriculum directors very happy, because
I thought you were going to say nervous, but
no, but it's exactly what we had talked about all morning, is that we need to look at where the student wants to end up, and maybe taking the SAT, so they don't all want to go to Harvard, maybe they want to go someplace else. And I really like the fact that discussion is happening, so that they do have a choice of what they take, and that it's more geared to what their future plans are, rather than what we think their future plans are.
Other comments? Or just real quick, Valerie, and you might have mentioned it, and I may have been, not focusing, but you've got on the list, this is year 4 of the original RFP.
Yeah, that's what meant. Yep,
Okay.
year 4 of it.
Any other questions, comments?
And then
Then
I
just-
also, okay, good.
Yeah, go ahead, continue.
Thank you. Rachel had asked me for some information on the assessments used in different states in the U.S. And Education Week had an article on it this spring in May. So it actually was between when you asked and this board meeting. That's just perfect, wasn't it? And it actually lists all 50 states. It tells what tests they use for grades 3 through 8, what they use for a high school test, whether they have an exit exam in order to graduate from high school in that state, and then any notes that they wanted to add. Now, it's actually an interactive article out of Ed Week, and I put the link at the end. When I pulled it up and ran it, you couldn't read the lines, and so I reformatted it a little bit here. But if you want to work with the interactive article itself, the link is here to do so. So I will ask Don Lynn to distribute these. And, am I done? Okay.
No, thank you,
Madam-
Valerie, for sharing that information. Yes, Pat.
I'd like to, if I may, at some point soon, see the actual contract with this organization, as well as the actual addendum that we're signing.
Yeah, so what you will have, or what Valerie just presented will be part of the deliverables, but we'll get that contract and how those addendums would work annually, so you can see that.
I'd like
So-
to see that, and I have some, I guess, concerns about year 5 of that contract that at some point I might like to visit with legal staff about.
Yeah, and so actually what we're doing is exercising our ability to not proceed with a year 5, right? This one is actually year 4, which will be that. So issuing our RFP and making sure.
Is
that's
that
aligned.
provision in the
Yes,
addendum?
Yes, it is. So it's an option that we are able to exercise.
Or in the
on an
contract?
annual basis.
Okay,
Yeah.
well, that's, again, I'd like to see
Yeah,
that.
yeah.
I'd feel more
I'll look back
comfortable
here.
voting on that issue.
Yeah.
Thank you.
Pat, I think you bring up a really important, and we didn't spend much time, and I think we probably will between August, September, October, in how we start the visioning process for what's assessment look like from 2017 and beyond. And part of this information that Valerie researched for us, she probably already, she really well, Jeremy, send the information to her. The information she gathered is started the foundation information for us to have and start thinking about. So we're going to be very involved as a full board in a lot of discussion about assessment next year as we look at 2017 and beyond. Okay, continuing on with assessment. We'll have action item 7.4 tomorrow on the agenda to discuss our testing for our English language proficiency. And Diane Steamer and Terry Schuster are here to talk about that. So I'll turn over to the two of you.
All right, thank you. Tomorrow we are going to ask you to approve a contract, or ask you to allow the commissioner to approve a contract with UCLA, and it's for the continued development and providing materials for the English language proficiency assessment. So I've asked Terry to provide you some information. We were here in January, and we're sure you remember everything we said then. So Terry's going to update you a little bit about the background of the English language proficiency assessment and where we are today.
Thanks, Diane. And before we begin, I want to say that my notes, I think, have been entered electronically into your board materials. And I do want to introduce someone, Brooke. Wave, Brooke. Brooke David has joined my Title III team of 2. And I think last time I mentioned her, but she unfortunately had another meeting at that time. So I did want you to see Brooke. And she brings a lot of experience with ELL after working with international students at the university as well as nonprofits. And she got her start as a Benson Bunny high school teacher in Omaha. So we're really excited to have her on our team, and she's been helping us too a lot with assessment, so we appreciate that. And you may remember from last time, and also I've talked to several of you already, and this will be the third time you've heard my presentation, and so I think you've had opportunity to learn, and there'll be a quiz then at the end. So, but those of you that only heard it once, we'll give you a few more times. But I just wanted to start off with a little bit of the history of English language proficiency assessment, and it has its beginnings in, of course, your friend and mine, NCLB. And so under Title I and Title III, it became a requirement that states develop English language proficiency assessments that assess the 4 domains of language, which would be reading, writing, listening, and speaking. And it would be given annually. And so those results in those early days were used to calculate Title III accountability, as well as the results of the English language proficiency assessment were used to as they are still today, to determine proficiency, whereas students can exit the ELL status, which is what we're trying to do in ELL, is always work ourselves out of a job. So that it's been a great help to us. We had a very good test, the ELDA. That was the very beginnings, and it was developed similarly and the same as we developed ELPA 21, in that it was a collaborative of states that got together that were funded by a federal grant, an enhanced assessment grant. And that's really the only way for a small state like Nebraska to be able to develop such a product, because it costs so much money. So we tried to join forces with our other states to develop our tests. Some differences between the ELPA 21, which is our new test, and our old test, which we call a legacy test. If you really want to, the new assessment term is legacy test, but it's really an old test, right? And it was all paper pencil, and this test is all online. And it becomes a little bit complicated when you try to assess the 4 domains, which we're still required to test when one of those domains is speaking. And if you think about how to do that, it becomes a little tricky. In our old test, the speaking part was given on the fly, which I will explain. On the fly means at the time there's an interaction between the test giver and the taker, and there's a rubric of sorts and a score is entered on the spot. Whereas when we're doing it online, the speech has to be recorded. So that meant our schools this year in the first administration had to use headsets with recording devices, and the students had to learn to listen to the features, the playback features, and be able. It's quite complicated. But, as we know, our kids are far more technology advanced than we are, and it turned out not to be too much of an issue. Although it was a learning curve, and it certainly was a learning curve. So that's a difference between our old test and our new test, one of the main differences. Our test, as I said too, is also different from NISA and a little bit more complicated because we have that element. So while our districts were used to online testing with NISA, they were not used to the complexity of this test. So it does take a little bit of skill on the part of the test administrator, and we hope next year that we will be pros at it by now. Another difference is that we test all students K-12, whereas NISA is just a few grade spans, and I guess becoming fewer all the time, as the last presentation just said. But we must test all students in grades K-12, and if you can imagine, kindergarten and first grade becomes lots of fun. Brooke and I did have the chance to go and visit a first grade while they administered our kindergarten, actually. It was kindergarten. As well as Brooke was able to go and watch one of our blind students take the test, which is very interesting. So we try to get out there and make sure we understand what's going on. But anyway, moving forward, as we know, last time I talked to you, we were able to deliver the test. We had a 1-year contract with Questar to deliver that. The grant period is now ending. It'll be ending this summer, and so we have to figure out other arrangements. So it turns out that ELPA 21, the intellectual property of it, is going to be housed at the University of California. UCLA, in fact, at CREST, which is their research arm for student evaluation and testing. And we are excited about that because we'll be able to continue to make improvements to the product, and the test will be able to be sustainable, and that new items can be developed, which was a problem with our old test. When there was no way to develop new items, they became old, and then we ended up giving students tests that had items that showed a student going into a video store and picking out something. So this is it's very exciting that we would have a way to sustain our test. But in order to do that, we do have to belong to the UCLA CREST group that will be ELPA 21. And so part of the contract that we're asking you to approve includes that portion of it where we are actually belong and are members of the ELPA 21 group, so that we have access to the test. Another piece of that contract would be delivery of the test, which is the vending part that we had hired Questar to do last year. And going forward, what will happen is that the states that want the comprehensive services will be able to leverage larger in size of students and get a better price, hopefully, together with Crest at UCLA letting the RFP in order to get subcontractors to deliver the vending services to states. So we would still have a competitive bidding process, but Nebraska would not have to go it alone, so to speak. One thing I want to point out about ELPA 21 too, that I just want to, I've been deeply involved in the development of the test and put in a lot of, I did say blood, sweat, and tears, but maybe not blood, but I will tell you sweat and tears for sure into the development, and have been on mainly every committee possible for it, as well as Brooke, was trial by fire when she started. I'm like, you're never now on 6 committees with ELPA 21. But the beauty of it is that we were instrumental in its development and making sure that it meets the needs of Nebraska students by our input, as well as our stakeholders and educators across the state. Whenever I call on Nebraska teachers, they are quick to volunteer to come and work on all aspects of the test. And we had volunteers that served as item writers, they served as content and bias reviewers, they did cognitive labs for blind and low vision item reviews. They did, they worked on range finding, actually went to Minnesota and did that. And they are going to be participating this summer in the standard setting process, and those activities should be concluding at the end of July. As well as Nebraska students participated in the field test, and that's very important because Nebraska student data is then included in the calculations for the leveling that happens during the standard setting, and we always want our students' data to be included. So for Nebraska, this is the best choice. Someone asked me earlier today, are there other English language assessments out there that we could view? Yes, there are, but they are not, their items are not written to the Nebraska ELP standards, and they do not have the work of Nebraska educators or folks at NDE like myself overseeing them. So I would not recommend them. I included in your materials a cost estimate that hasn't changed since I first gave you that in January for the first year, where we are estimating at $521,400. Although I expect that to be lower actually, because I found out that fewer students took the paper pencil exam. That most of them took the online, which is a cost savings. It is a 3-year contract that we are looking at for approximately $1,604,000. Our funding source would be federal assessment funds. And I don't know that I have anything else, but in case you're wondering about ESSA, that nothing in testing has changed, so we're still under the same requirements, so nothing changing there. And we would be conducting a bridging study between our old assessment and this assessment to make sure we complete that transition in these 2 transitional years. We will be able to report to the feds on still students making progress and learning English. So we have those plans that we're working on now. Any questions?
Right. Are there any questions? Lily?
Of course, I can think of something I didn't ask earlier. Instead of saying legacy or old, I'd say former.
Former, there you go, that's much better.
The other 10 states, you said Minnesota, it sounded like.
Well,
didn't you?
Minnesota is not in the consortium, but some of the work, the testing companies are in Minnesota, and Questar is, as well as DRC, although we didn't work with them.
Off the
so
top of your head,
did not
do you
work with
remember
DRC.
the other states?
They went there. That's where the range finding activities were conducted, and I believe in St. Louis is where the standard setting. But the other states that are involved in the ELPA 21, just to review, are Kansas, Iowa, Arkansas, Washington, Oregon, West Virginia, Ohio, and South Carolina.
Good job.
And Louisiana. Sorry.
I'm impressed. Thank you.
Any other questions? Thank you, Terry. Thank you, Diane.
Thank you.
Next, we'll move on to item 3, Student Success and Access Reports. I'll turn over to John Witzel.
Thank you very much. We had a very good Success and Access Domain Committee meeting this morning that included tenant reports, which from Rich Cott and Lindy Foley. Rich briefed us on a lot of ways in regards to the special education and VR workshop transition guide that is being incorporated now. Also, he mentioned the work-based learning website information, which is going to be coming up and operating very, very quickly. And that is supposed to be very, very significant, which is being worked from a grant through VR and special education. Brad Dirksen briefed us on the upcoming revisions to ELL Rule 15 and some other updates. And in regards to positive relationships, partnerships, and school success, Zanab Rita gave us some basic information on what she was doing. And now I'd like to turn it over to Jolene, who will brief us on safety and security.
Well, good afternoon. I'm Jolene Palmer, and I'm the Safety and Security Director of the Nebraska Department of Education. And tomorrow, we are bringing before you the opportunity for you to adopt, or asking you to adopt, some safety standards that we have created over the past 16 months. It seems like a long time, but now that we're here, it's like, oh, I wish we had about 3 more months, but that's not right either, because we want to begin our work. Back in April of 2014, the legislature passed a bill which became Law 79-2144, which created or gave Dr. Bloomstead the charge of identifying a state school security director, of which one of the duties of that director was to create minimum standards for schools in terms of safety. And so a committee of 40 people, or about 40 people, have been working on those standards to help schools be guided in the process of what it is that we need in terms of best practice for safety and security in our schools. And so we have those standards before you, and tomorrow as you come, we're going to ask you to adopt those. And like I say, I will tell you from the feedback I get from schools, they are requesting help and guidance as far as what do we need, how do we do it, what's best practice. And so we have several tools, but the standards will be before you, and then the tools will be guiding practices for schools as they go forward.
Any questions or comments of John, Jolene, or Frida?
I just wanted to also add, I'd like to thank Dr. Anderson, Sue Anderson, and her team for the priority school update also provided this morning. Thank you very much, Sue.
Great, thank you very much. Thanks, John. Next, we'll move on to item 4, Data and Continuous Improvement Report. Glenn, is there any report from the Data and Continuous Improvement? Yeah, no report as far as.
Well, one thing, I'll just give kind of a quick, we have several different elements of work going on around how we pull this together, and we probably will do a phone call or something with the committee this summer on some key elements and timelines of that work, so I appreciate that. You know, we haven't got Glenn too busy yet, but now the time is there. So.
That will happen, okay. Next, we'll move on to item 5, and I think just quickly on item 5, and Commissioner and Donlin, you can jump in if there's something. The Strategic Planning Committee met this morning at 8:30 with the FSG to provide some feedback and input in the overall process. And then, as you know, there were meetings with both the teaching and learning domain and the student success domain around how the current proposed elements of the plan intersect and the strategies intersect with the tenants and the 2 domains, and FSG will be putting all of that feedback together. And then the Strategic Planning Committee will meet in both June and July with staff and with FSG with the goal of draft document being ready in August. Again, it will be a work in progress. Staff certainly may have some input, board will continue to have input, but it's moved quite a long way from the discussions, at least from my view today. So we'll have more of a report in August. Are there any questions of Don Lynn or Matt relative to strategic planning?
Good sessions this morning. Thank you very much.
Okay, we're getting a little tired. Policy Committee. Pat, Tim, what do you have for us on Policy Committee?
We're going to bring a draft for approval on Policy B7, which addresses reimbursement for expenses. We started this in April and have had very good discussion, and I think have come up with something that we're all very willing to recommend to the rest of the board. And we wanted, I think there was a little confusion last month as to some wording, so the wording was rechecked and I think is consistent all the way through now. And so it's attached to your computer, so we'll bring it forth for approval tomorrow.
Any questions of Pat or of the action item on State Board Policy B7 for tomorrow? Okay, hearing none, we'll move on to item 7, legislation. Lily Larson and maybe Brian.
The Legislative Committee did not meet, but I'm sure that we can have some general update from our counsel, Brian Halstead, as to work that I imagine is going on with the Legislative Education Committee. Brian.
Good afternoon, Brian Halstead, Deputy Commissioner. If you didn't notice, there was a lot of discussion about issuance by the U.S. Department of Ed on some Title IX guidance earlier in May. What the U.S. Department of Education actually did do on rulemaking was this past Tuesday, May 31st, they published in the Federal Register their notice of rulemaking for ESSA as it relates to Title I accountability and reporting on state plans, and the 60-day comment period that's available until August 1st for entities like the State Board and the Department to issue comments on their proposed regs under ESSA. They actually have begun the official rulemaking on ESSA, which the President signed back in December. It was only 488 pages long, so I can't give you a really good summary of that at the moment since we're only 2 days later. But that is a process that's going to be undergoing. We at the department are going to clearly be analyzing what those proposed regs say about accountability and the consolidated state plans that are going to be required under ESSA. There was yesterday a webinar that CCSSO provided on this, and today, if you weren't aware of it, Diane Steamer and some of her staff were in a webinar that the U.S. Department of Ed provided on what those proposed regs are doing. So as you notice, we're kind of juggling a whole lot here at the moment. So I think what we plan on doing going forward is we will certainly be looking at the proposed regs, prepare some prepared comments that the commissioner could submit, and maybe the board president, and we'll certainly be bringing together our policy partners. If you remember, back in the early part of 2015, this board approved a joint statement that NSEA, NCSA, NASB, NERCSA, the Rural Community Schools, STANCE, and ESUCC all joined in making comments at that time. I know the commissioner and I had the opportunity, along with Deputy Friesen, to meet with U.S. Senator Deb Fischer this week, and she was very appreciative of having a joint statement that she could rely on as she went to vote on ESSA. So I think we're going to probably follow that same process here on just these proposed regs. They have not yet issued proposed regs for assessment and other pieces of ESSA, which we anticipate are going to be coming in the next month or so. So the U.S. Department of Education actually is trying to promulgate rules and regs and not doing this through guidance. So I'll answer any questions you might have.
So at this point, we would, between now, May 31st to July 31st, have some review of those proposed regulations?
Yes, absolutely.
And then you will respond, and then will you share with us a copy of your response since we do not meet in July?
Absolutely. I think that's our intention. I mean, obviously, it would have been nice had the deadline for this been sometime like August 6, 7, and 8 after your next August board meeting, but that's not going to occur. So I think at this point, we do intend to bring at least the board legislative committee some of that and everything in that working. We certainly do intend to seek out to our policy partners as to what they're thinking on the proposed regs that have been put out. I doubt maybe Jay has read it all, analyzed it all, and has the comments from them. I doubt it. Yeah, in that regard. So as you can see, they have finally begun to actually promulgate the rules and regs under ESSA that we're all going to have to comply with. So.
And one of the things that I think would be appropriate for us to do is, as we review it, we will certainly keep you up to date relative to what we're seeing and the types of statements that we think we might make. One of the things that I think, at least as a provision, that whether it's, Rachel can speak as board president in a letter or however we want to do our comments, but we can circulate those or call folks together appropriately to make the right statement. And clearly, if we see issues or struggles, we'll be highlighting those ourselves. So thanks.
Thank you, Brian. Any questions or comments? I do think it's an important topic, and there will be probably some communication going out so that we make sure we take advantage of the opportunity for us to review and have comments as appropriate. So, any questions or comments? Thank you, Brian. If not, then we move to item 6. Item 6 is the regularly scheduled meeting of the State Board of Education will reconvene at 9 a.m. tomorrow morning in this room. Just a little after 4:30, and we are finished. So see y'all tomorrow morning.